First, he's here with Mr. Chesnoff and Mr. DeGuerin, Mr. Milius, Bailey, and Henderson. Miata and Lewin are present. Mr. Lewin at the lectern. Dr. Loftus has returned to the witness stand where you remain under oath. You may continue with your cross-examination.
Thank you. Doctor, I want you to assume for a moment that Tim Hennis was convicted of the murders in April of 2010 in his last trial that involved the DNA. I want you to assume that for a moment. Are you following me?
Yes.
You did an article, an interview that was published, that was printed on November 11, 2010. It was called Unforgettable by Patrick J. Kiger. Do you recall that?
No.
I tried to show you this article over the break. Is that correct?
Well, you tried to, yes.
And your response was, quote, I didn't write it, correct?
Well, it doesn't even look like an interview, and it's not a quote from me.
Well, so, Doctor, you're telling me you have no memory of doing an interview that appeared in Orange Coast Magazine, the community where you teach.
I've done hundreds and hundreds of interviews, and hundreds and hundreds of articles have been written about me. That one does not look familiar.
So, Doctor, in the article, it says as follows. In one early case, she worked on behalf of, in a North Carolina case, she...
What is the purpose of...
Okay, right. So the witness is not familiar with the article.
I've shown her the quote.
There's a quotation?
No, I've shown her what is alleged that she said in the article. Your Honor, I discussed this in chambers.
Right.
I'm gonna
Okay, so you say that there's a quote attributed to her.
No, Your Honor, there doesn't have quotation marks around it, but she is being interviewed, and she is explaining what happened in the case. I indicated in court chambers.
She said she's not familiar with it.
So
it's presented differently right now.
So, Doctor, you are aware when you give your interviews, right, you frequently go through the cases that you have worked on and that you have testified on, et cetera. Is that correct?
If I'm asked about a case, yes.
In this article, Doctor, there is a discussion in the article about the Timothy Hennis case. Is that correct? I showed it to you.
I believe there was a sentence or two in a long article, yes.
And would you agree that that article simply says that Hennis was convicted of rape and murder with a new trial at which he was acquitted? Nothing more.
That's what the article says. That's what that person wrote.
So whether, in fact, you gave this quote or not, Doctor.
I did not.
So you don't remember. Well, now you're saying you've given hundreds of, you just said a moment ago, you've given hundreds of interviews.
It's
so
not
do you know?
It's not a quote.
Let me finish my question.
Let the witness finish, and then ask the next question.
Mr. Chesnoff's suggestion is a good one. Wait till the witness finishes her statement and then ask your next question.
What you showed me looks like an opinion of an author who wrote an article and wrote a sentence or two about it. I do not control the journalists in this society.
But, Doctor, would you agree, though, that if an article is published and you become aware that an article, a profile of you, discussing what you do, simply mentions Timothy Hennis as if he was acquitted, meaning he was wrongfully convicted of murder, and then there's nothing about what happened after that, would you agree that would be misleading?
Well,
What's sustained?
Are you telling me that you've had no idea until I brought it up today? You had no idea about this Orange Coast Magazine article until I brought it up today?
I don't remember that article. There have been so many of them. I don't remember that particular one.
Would you feel, Doctor, that you would have a duty if an article came out that only had half the story, that did not, in fact, include the rest of the story, what had happened to Sergeant Hennis? Do you feel you would have an ethical duty to correct it?
Objection, relevance.
Overruled.
Not necessarily. There's too many articles out there with little mistakes in them, and I don't have time to write to every single journalist to correct every single mistake.
But you do have time to write to individuals like Jerry Sandusky, who are accused of multiple counts of child molestation.
Objective, argumentative, Your Honor.
All right. Let's talk about your work overall. Is it fair to say that when you have testified, it has primarily been as an expert on the side of the accused?
In the criminal cases.
Yes. And that many of your cases, your high-profile cases, almost all of them have involved either murder, rape, or child molestation?
Well, sometimes there are other crimes, robberies, or fraud, or other kinds of crimes.
No, I asked about your high-profile cases. Those have all been either rape, murder, or child molestation, correct?
Well, I have not categorized the cases that way, but there are a lot of cases involving murder, and others involving rape, and some involving child molestation.
Would you agree that you have some controversial opinions regarding individuals who, as adults, report years-old child abuse?
There is controversy in that area, yes.
What I asked you was, do you agree that you have some controversial opinions that have been criticized by even fellow academics regarding the situation of individuals who, as adults, report years-old child sexual abuse?
Yes, but there's been criticism.
And do you recall saying the following? Why do people do this? There's an obvious benefit. This is regarding adults who come forward to report decades-old child abuse. Quote, why do people do this? There's an obvious benefit. It may not be immediately financial, but certainly being bathed in a love bath of attention and affection is a lot of benefit for a lot of people. You said that, correct?
I've said something like that, that is a reason why somebody would want to believe something happened to them that might not have happened.
You said this in September 28, 2007 Time Magazine article piece by Amanda Ripley. Is that correct?
I don't remember that long ago article.
Would you agree that that statement seems to be very hostile towards individuals who are reporting decades-old child sexual abuse?
Argumentative, Your Honor.
Overruled, let's go sidebar. All right, you may resume. Here's yours. Whoops, not yet. All right, you may resume your question.
Doctor, that comment where you talk about people liking being bathed in a love bath of attention, meaning... Oh, speak up? Sorry. Let me say that again. That quote that you said sounds similar to what you've said. In essence, makes the comment that individuals who are reporting child sexual abuse, that those individuals are being bathed in a love bath of attention and affection, and that that's a benefit for a lot of people. Would you agree that that statement would seem to minimize your sympathy for those individuals who are reporting these kinds of acts?
Well, when you take it out of context as you're doing, then yes, but there are obviously many genuine cases of child sex abuse, and people are reporting authentic memories, but there are also false accusations, and I've been asked the question, why would somebody want to believe something that isn't true? And that is one reason.
And you use the term love bath. What do you mean by that?
In some of the cases that I've been involved in, people who have developed false memories end up getting a lot of attention, sympathy, occasionally a financial reward, identity, and that is a reinforcement for them.
So you found in your work that there are a number of these individuals who are reporting child sexual abuse who simply are doing it for either a financial motivation or because they want attention. Is that your experience?
In some cases, that's true. It's certainly not true in all cases.
All right. Let's talk about your history as an author. How many books in total have you written?
Over 20 books I've authored or co-authored.
Your books always have dedications and acknowledgments, is that correct?
Often.
Have you ever dedicated a book or acknowledged a victim or a victim's family in one of your books?
Objection, Your Honor. Argumentative,
What?
352, it's just, I mean,
Yep.
Goes to bias, Your Honor.
what-
The witness has said she's objective.
All right, I'll allow this question.
I don't recall doing that, no.
You were asked about this in the Jackson case at page 53, lines 1 through 14. And you mentioned that you considered accused defendants, who you have acknowledged in your books, you considered them victims of the criminal justice system, correct?
Yeah, actually, that's true. The innocent people who've been accused are victims themselves.
And in fact, you thought one of those was Tim Hennis.
Oh, I definitely thought he was wrongly convicted at the time, and now I have questions.
I want to talk about your articles. How many articles have you written?
Over 600 scientific articles and chapters over the last 40 or 50 years.
Would you agree that your articles are slanted towards defending and not prosecuting criminals?
objection, Your Honor, argumentative.
Oral?
The articles primarily report the results of my scientific experiments that
Would-
I've been doing over the last, 4 or 5 decades.
Would you agree that the lawyers that you mention in your books and lectures are almost always defense attorneys and never prosecutors?
Well, that may be true. I have more contact with defense attorneys, certainly, than I do with prosecutors.
Did you author an article titled, quote, "Play to the jury you select in complex and other cases"?
That was an article I co-authored on jury decision-making several decades ago.
Does that sound neutral and unbiased to you?
No, it was about jury decision-making. It
Well-
does not sound all that neutral. It sounds like a title that, in a lawyer magazine.
Let's talk for a moment about false memories. Your main theory with respect to false memories is they can be implanted through both suggestive or leading questions, and they can be implanted intentionally or unintentionally. Is that correct?
Yes.
For instance, if a person witnesses a robbery and then is subsequently asked, hey, how big the robber's knife was, the person will believe and might testify that all of a sudden a knife was used in the robbery, even though a knife might not have existed at all. Is that correct?
That can happen. That could happen.
And your testimony is frequently used to suggest that eyewitness memory is based on false memories that's created by suggestive or leading information provided by law enforcement in the course of their investigations. Is that right?
Well, sometimes there's improper testing that leads people to identify the wrong person.
And this ends up going back to the idea of that's why it's so important to make sure those interviews are recorded so that you know what those witnesses were told when they later give certain statements, correct?
That recordings can be very useful, yes.
Is it fair to say that you have built a very lucrative career coming to court and testifying that witnesses' memories are unreliable?
My full-time job is a university professor, and that already is lucrative enough.
Well, you don't make $700 an hour as a university professor, do you?
It depends on what I'm doing.
What do you make a year from your position at UCI, doctor?
Is that a question I'm supposed to
Yes.
answer, Your Honor?
Yes.
I believe my salary is approximately $270,000 to $280,000 for a 9-month appointment.
So, I just want to, I can't do the math, Mr. Bailey. If you could just do the math real quick, and I'll get back to you on what 40 hours a week of $700 an hour would be. I forgot, you have a degree in math, Dr. Loftus, so you can probably do this better than I can. If you make $700 an hour and you work full-time, that would be 2,800, I'm sorry, 700 times 40, that would be $28,000 a week, which would be, am I right, I shouldn't do math.
Let Mr. Billion do the
Yeah, I should not do math. Oh, I was, okay, I doubted myself. That's $28,000 a week. Does that sound like then the kind of money that
No,
you're?
that doesn't, no.
So when you just said a moment ago, it depends on what I do, you don't make anywhere near $700 an hour.
If this year I gave a lecture to a psychiatry department on Zoom for an hour and I was paid $1,000.
Okay. How much, by the way, how much have you made over the years as an expert witness in total?
I wouldn't be able to answer that question.
Would you guess probably more than $1 million?
In 40 or 50 years, possibly.
What-
I have never calculated that.
Well, doctor, would you guess we're probably talking millions with an S?
The usual question I'm asked is what % of my annual income comes from consulting or
Right.
from outside activities?
Yeah, I'm not the usual guy asking the question, so I'm going to ask the ones
Well,
I
I
want to
can't
ask.
answer your question because I haven't done that calculation.
Well, would you like to do that calculation now?
No,
What were you paid on the O.J. Simpson case?
nothing.
What made you take that case?
A Nobel Prize winning psychologist asked me to become involved in it.
Did it matter to you in terms of whether or not Mr. Simpson was guilty or not guilty?
I examined a particular issue and ended up not testifying in the case.
What'd you get paid for Bill Cosby?
I don't recall exactly. At that point, I was probably charging $600 an hour. Yes, I was.
And doctor, you put a lot of hours into Bill Cosby.
No, I didn't.
Well, give us an estimate approximately of how much you got paid on that case.
I don't recall exactly, but under $10,000.
Under 10,600, that's like, what is that, 20 hours worth of work? Less? Is that all you put in?
Your math is off, but never mind.
Well, tell me. Listen, I don't have the math.
I may have gotten $6,000 in that case. I don't recall.
Okay. You already talked about Harvey Weinstein. Are there any high-paying defendants that you've ever turned down?
I don't know. I've turned down cases. I don't take the cases for the money.
But you've upped your fee. It was $500 an hour in 2012. It was $600 an hour with Harvey Weinstein, and it's $700 an hour now. So
Misstates the evidence, Your Honor.
you haven't? Didn't you say it's now $700 an hour?
Not for
I,
this.
sorry, Your Honor.
I'm sorry.
Overruled.
No, I raised my rate in June to $700 an hour.
So when you said it's not about the money, you've gone from $500 an hour in 2012 to $700 an hour now. Do you consider $700 an hour to be an exorbitant amount of money per hour, given what you make in your normal job?
I consider it an appropriate fee, given what experts with my level of expertise and experience are charging for their time in litigation.
When were you retained on this case?
Approximately February 2020.
Did you know any of the defense attorneys prior to this case?
I did, yes.
Who did you know?
Well, I knew Mr. Chesnoff because I worked on a case of his maybe 20 some odd years ago.
So you previously had a relationship with Mr. Chesnoff where he retained you as an expert and paid you, is that right?
Well, I was paid in that case. I don't remember how much. It was 20 years ago. But
What were you asked to do in this case?
examine the memory aspects of this case, of which there were many.
And Doctor, were you told that the issue you were to look at, were you to address whether a witness was lying, whether a witness was mistaken, or whether maybe a victim who was telling information was lying? Were you given any of that direction or no?
Not that I recall.
How many times you met with the defense during this case?
Well, we met prior to this testimony. We met on a prior occasion, maybe it was in June or so, in person. and there were a number of meetings on Zoom or some other remote platform because of COVID.
So you said you only billed $6,000, you think, at the most in the Cosby case, is that right?
Approximately.
Yeah, how much have you billed in this case?
I already testified that I received, for the year and a half of work, about $46,000.
So you got $6,000 for Bill Cosby, you got 14, I think you said, for Harvey Weinstein, and you got almost 50 on this case?
Well, these lawyers are so thorough, they demanded a great deal of time from me and sent me a great amount of information to review.
And by the way, does that include your testimony today?
That we agreed will be the total bill, yes.
So would you agree that that's 73 hours of work, right?
Well, I believe the figure was more like 77, but I've worked more than that, many more hours than that.
Well, you would agree that I was told by you can tell me this is wrong, Mr. Chesnoff has said you were paid $46,300 for 73 hours of work. Is that correct?
Okay, then it was in the 70s, but I've actually worked more hours that haven't been billed for.
Oh, you should be 77, you're saying? You indicated you're still employed right now as a tenured professor at UCI, is that right?
I am, yes.
And in fact, today, while you're in court, being paid as a witness, you're also being paid your salary by the taxpayers of the state of California, correct?
No, my salary is a 9-month salary. That's September to June.
So
So I'm not paid in the summer by the university.
when you testify in cases that occur during the school year, you're still paid, you still get your same salary, correct?
During the school year, yes. Well, we have a policy of being able to do outside activities. I believe it amounts to 1 day a week or so.
So in essence, the policy for you is you get paid roughly $250,000 a year to be a professor at UCI. But if you want, you can take a day a week and you can bill now $700 and you can get paid by the taxpayers of the state of California and then bill wealthy individuals, if they can pay your money, $700 an hour. Is that right?
In principle, yes.
Well, not in principle, in practice, correct?
No, because your numbers were wrong. I said 270 to 280,000, and you misremembered it.
Oh, your memory is very sharp in this area. You would agree it's much better in this area than it is about your prior statements to different periodicals, correct? You seem to have a better recall of this area than you did in some of my prior questions. Would that be correct?
Well, when you're asking me questions about things that happened
So,
5, 10, or more years ago,
Doctor, you understand what your discovery obligations are in the state of California, correct? As an expert, that you have to turn over stuff that you have, et cetera, correct?
I don't know what you're talking about.
What?
You don't need to subject.
No, I'm objecting.
Yeah, sustain.
What?
It's a lawyer's obligation, not the witness.
When did you turn over to Mr. Chesnoff the 26-page document that went through your summary of what you had done? When did you turn that over to Mr. Chesnoff?
I believe it was 2 days ago. I gave him my notes.
Doctor, you're aware, having testified as an expert in this state for 40 years, that you are supposed to turn over your records, reports, et cetera, when they are asked for, well before 2 days before trial, correct?
Records and reports, not notes.
That's not
I
correct.
object, Your Honor.
Yeah,
Same basis
exactly.
as before.
Yeah, sustained on the same basis. The lawyer has the obligation. The obligation belongs to the lawyer.
Dr. Loftus, were you aware that Mr. Chesnoff and myself had both sent you emails requesting any materials that you had on this case, and that had been going on for weeks and months?
I did not think I had any obligation, I don't ever recall turning over notes to a prosecutor in 40 years of doing criminal cases.
So it's your position, you're aware that Mr. Chesnoff, you said he got your notes 2 days ago, and you're aware that he turned those notes over to me 2
Yes.
days ago, correct?
Yes?
Do you think, is that the first time, by the way, doctor, that you became aware that Mr. Chesnoff was asking for those notes? In other words, was it Mr. Chesnoff who erred in not asking you for them, or was it you who, despite repeated requests by Mr. Chesnoff, did not turn the stuff over before then?
Facts not known.
Sustained.
Well, doctor, what was it that made you turn your notes over 2 days ago?
Because there was a discussion about whether the notes should be turned over or needed to be turned over. Mr. Chesnoff solicited a number of legal opinions from different prominent attorneys about what the best course of action was, and he decided that the notes should be turned over, so I gave him my notes, and he Xeroxed them and turned them over.
So it's your position that Mr. Chesnoff did not ask for those notes from you well before 2 days ago? Is that your testimony?
I don't remember him asking me to turn over notes.
All right, doctor, did you write a report in this case?
No.
So $50,000 approximately that you've been paid, and there's no report, is that right?
I did not write a report.
And doctor, you're aware that if you write a report, that report has to be turned over, correct?
If there is a report, then I would,
Overruled. But you need to tread, this is a narrow inquiry.
It is. You're aware, doctor, that if you write a report, it gets turned over if you are used as a witness, correct?
I don't know about that, no.
You didn't know that. In the scientific method, a scientist like yourself, right, they write reports of their observations, opinions, and conclusions so they can be analyzed by other scientists and determined to be either replicatable, to be problematic, et cetera. That's how it works in your world, correct?
That's typical scientific method, yes.
But you're aware, doctor, that in this world, if you end up not turning over a report, then the prosecutor doesn't have the same kind of ability to analyze what you're going to say as your scientific colleagues do when you write a paper or an article, correct?
Well, yes, there was no report you could use to determine what kind of questions you wanted to ask.
But you don't ever write reports in these cases.
I
do you?
write reports in civil cases when it's required.
So, again, in criminal cases, you don't ever write reports because you know that those are going to get turned over to the other side, correct?
That's not true.
What's the
Overruled.
grounds?
The answer, no, may stand. That's not true, may stand.
Sorry, Your Honor.
She answered, that's not true, and that answer may stand.
Okay, thank you.
Doctor, is it your testimony that on cross-examination today that you have made the same effort to answer the questions I've asked as you made with Mr. Chesnoff when he was asking you questions on direct?
I've tried to answer your questions.
I'm asking you, doctor, do you notice, as a trained psychologist, do you notice in any way that there has been a resistance to answering my questions, the questions I ask on cross-examination, versus the questions that Mr. Chesnoff was asking you on direct? Would you agree to that?
Probably, yes.
You know from all your years in court what a hypothetical is that correct?
I'm sorry, I didn't hear you.
You know, doctor, what a hypothetical is, correct?
Yes,
And you would agree that it would be true that when you are given a hypothetical, you are asked to assume certain facts to be true, right? And then you give an opinion based on those assumed facts. Is that correct?
yes,
And you would agree that as an expert, when you are told to assume certain facts, it's not your role to question the accuracy of those facts. In other words, you're told the following facts and then you're told to give an opinion, correct?
yes. Well, the opinion was the same. Is the scientific literature relevant to this hypothetical situation.
Would you also agree that the job of questioning facts in a hypothetical, that's the province of the opposing attorney and the judge, right? Not the expert. Would you agree?
I responded to the hypothetical as it was given to me.
That's not my question. Again, listen to my question. You agree that when a hypothetical is given by an attorney that assumes certain facts, it is not for you to question the facts in the hypothetical. That would be for either the judge or the opposing attorney. Would you agree?
This is beyond my area of expertise. Maybe I don't know who should be questioning.
It's beyond your area of expertise, doctor, about giving hypotheticals in a courtroom, which is what you do as an expert witness under California law for the last 40 years.
It's beyond my expertise to assume who is the one who should be questioning the facts of a hypothetical.
This next, Your Honor, is not refreshing recollection. This will be offered pursuant to 1235, which is why I'm not showing the witness in advance. In the Jackson case, do you recall the following exchange? This is going to be, Doctor,
You're showing it to counsel, though.
page 98, line 8, to page 99, line 8.
Had a chance to read it, Your Honor. Thank you.
Doctor, I'd like you to read out loud, please, starting on with the word okay, and I want you to read down. It's going to go to the next page.
So the question is, okay, so here is my hypothetical, ma'am. I'm simply asking you, would you agree that an 8-year-old seeing his mother being choked by someone that he cares about and having trouble breathing, and by choked, I'm using the word choked, meaning that one hand over the mouth, one hand over the throat, so that she's having trouble breathing, you would agree that would be a traumatic memory? Answer, I think that would be very upsetting. Question, and would you agree, ma'am, that that is the kind of memory that someone is more likely to remember than what you've called peripheral memories? Answer, if it actually did happen, yes. Question, and ma'am, would you also agree that in your studies, what the individual is likely to mix up are going to be peripheral details around that, so maybe the time it occurred or which hand it was rather than the actual event of the mom being choked in this fashion? Would you agree? Answer, if it actually happened, the gist of the event, some core details might be well retained and peripheral details would fall off if it actually happened.
Doctor, in that questioning, I believe 4 different times, you were given a hypothetical, and instead of answering the assumed facts in the hypothetical, you yourself chose to say 4 times, if it actually happened. Is that a correct response for an unbiased, neutral expert presented with a hypothetical to respond?
That was my response at the time.
Motion to strike is non-responsive. Please instruct the witness to answer the question asked, Your Honor.
Overruled.
Could you repeat the
No,
question?
you don't have.
Yeah, oh no, I'm going to repeat it.
Well, no, then I'm going to object.
Yes.
Stop and answer.
Which she did not answer.
Okay.
Doctor, this is my
Judge.
question.
Wait, hold, stop, let me look at this. Response to the time. Repeat the question, you don't have to, I'm going to repeat it. You may repeat the question.
Doctor, you agree that in what you just read, either 3 or 4 times, you were asked a hypothetical that assumes certain facts, and instead of answering, you responded with respect to the facts in the hypothetical, which were damaging to the defense, if it actually happened. My question is, does that sound like a reasonable response to an expert who is posed a hypothetical to question the underlying facts if they're true?
To me, these answers are quite reasonable.
Quite reasonable for an advocate, or quite reasonable for a hired gun, or quite reasonable for an unbiased, impartial expert?
Objection, Your Honor. Argumentative, Your Honor.
Well, in tone, but in content, I think not. You may answer.
Well, because there's scientific information in my answer to these questions. Even if I am questioning in my mind whether this actually happened.
But doctor, haven't you been told, isn't it your responsibility as an expert, you are not supposed to be going through the actual facts. You're supposed to be given facts, and then you take those facts and you give an opinion. So when you repeatedly say, if it actually happened, doctor, that's being done, correct, because you wanted that jury to believe that you yourself, with all your degrees and all your experience and all your credentials, were questioning the facts and not just giving a scientific opinion. Isn't that correct?
This was the answer that occurred to me and the answer that I gave.
So you're telling me that answer has nothing to do with you trying to be an advocate and help the defendant in that case at the expense of living up to your responsibilities as a credible expert?
Objection.
Sustained.
Is it your position, doctor, that that was the answer of an independent, unbiased expert?
Same argumentative.
Overruled. You answer.
No.
Please answer.
I stand by that answer, and I'm comfortable with it.
So I'm going to ask you to answer the question I asked again. I'm not asking whether you stand by or whether you're comfortable with it. Listen to my question. Do you agree that looking at your answers, that those are the answers inserting, if it actually happened 3 to 4 different times, that those are the responses of an unbiased, neutral expert?
It seems to me that I actually must have had some concerns that something misleading was going on, and to have said, if it actually happened 3 times.
Doctor, so you agree that instead of accepting the facts as I gave them to you, you decided that you were going to question in your answer the facts you were told to assume. That's what you did, correct? You questioned the facts you were told to assume.
I said, if it actually happened.
Is that any different, doctor, than if I said, I want you to assume that a person was on a blue bike and rode past the 7-Eleven, and you responded, well, if they actually were on a blue bike and rode past the 7-Eleven, that would be the same thing, correct?
It might be the same thing or something similar.
And would you believe that to be, again, the appropriate answers of an unbiased, neutral witness?
I don't think there is one and only one appropriate answer to a question.
Is there an answer to a question that demonstrates that you are an advocate instead of an unbiased witness?
Well, there could be.
And would that last answer demonstrate that with what you were saying, you were being an advocate and not an unbiased, neutral witness?
Your Honor, it's been asked and answered.
Overruled.
Can answer, please.
Oh. I don't know what else to say about this answer. It speaks for itself.
It does speak for itself. I'll move on.
Okay, do not comment on the witness's answers, please. That's argument. You'll have time to argue when the evidence is complete.
Could you strike that for me, Your Honor?
It's stricken.
Thank you.
I want to switch over to the topic of memory. You've testified that all memories are not created equal. Is that correct?
I don't, you'll have to show me. Where did I testify to that
All right.
sentence?
Let's make it easy. You agree, doctor, that not all memories are created equal, correct?
Well, I'm not sure what you mean by that. What do you-
Meaning, doctor, that there are some memories that are going to be more significant. So an example might be that if I walk out in the street right now and I see somebody getting shot, that that's going to be a stronger memory you would expect than what I had for lunch 2 days ago.
Yes, I agree that some memories are more significant than others, and
And you have said and testified previously that the more important or significant a memory is, the more likely somebody's going to remember it. Is that right?
yes,
That is an accepted postulate in your area of expertise. Is that right?
yes,
Do you agree that in a conversation, there will be salient details and unsalient details?
yes,
And this kind of goes back to the difference between gist and peripheral. Is that right?
it's related to that idea.
And the idea would kind of be that as an example. So let's assume that a person goes to dinner with a very close friend. And after that dinner, the close friend confesses to murder of another close friend. But when the person is asked later about what happened, they have a much stronger memory of the confession than they do, for instance, of what credit card was used to pay for the meal. Is that what you would expect, doctor, given your experience?
The significant aspects of the experience would be more likely to be remembered than ones that are peripheral or less important.
In the hypothetical I gave you, what was the more important, more salient,
Well,
less peripheral part of that example?
Certainly might be that there was a confession than the color of the credit card.
Well, you just said it might be. So, doctor, words are important. Would you agree? Are words important in your line of work?
Yes,
So when you say might be, can you give me a scenario? How on earth could there ever be a situation where the color of the credit card might be less important than the confession? Isn't it always going to be more important than the less important than the confession?
I would not want to say always. There might be some exceptions to the two, even this rule.
So there might be an exception where somebody's best friend admits to murdering their other close friend, and yet the salient part of that incident or conversation would be the color of the credit card they used, not the confession. Is that your testimony?
Make an objection to
What?
an improper hypothetical, not based on the facts, Your Honor.
What?
Overruled. The issue is not over the color of the credit card, but the witness introduced that fact, so that's changed the hypothetical. So overruled.
Thank you.
Please answer my question, doctor.
I would think in a standard scenario, a confession of a wrongdoing would be certainly more important,
Right.
more significant
Right.
than a credit card.
I'm just wondering, doctor, why did you use the word might in your first
Because
answer?
there could be circumstances where that might not be true.
Well, doctor, you recognize when I asked the question, you recognize its application to this case and understood that that's a question that if you answer, oh yes, it would certainly be more memorable, the confession, that could be damaging to Mr. Durst. You recognize when I asked that question, didn't you?
Well, I said that it might be more significant.
Right, doctor, my question is, why, given the example, did you say might be when you
Because
just
they're-
now, let me finish my question. When you just now conceded that it might be, you would expect it to be. Those are different, correct?
I would expect it to be,
So why did you say might?
because there's no certainty. There could be exceptions.
So you're not using the word might because you're trying to help out Mr. Durst at your $600 an hour payment. Is that your,
No, I'm not.
okay, let me continue. You've also said previously that there is an absolute advantage for salient details being remembered in memory as opposed to non-salient details. Is that right?
That would be true.
And again, you would agree that the more important and significant the memory, the more likely it will be accurately remembered. Is that right?
Yes.
By the way, you were asked that. Is that a yes or a might be yes? Is that just an absolutely yes? That question?
There might be some exceptions to that.
Well, do you recall, you were asked that question in the Jackson case, the identical question, and you responded probably yes. So my question is, why when I ask questions that are damaging to the individuals you are in court testifying for, do you use qualifiers like might, probably, possibly? Why do you use those qualifiers and then later concede that actually, no, there's no qualifier, it just is?
No, I disagree with that.
What do you disagree with, please?
There could be exceptions, and as a scientist, we often avoid saying always or never.
When,
So we're much more comfortable with probably.
when Mr. Chesnoff was asking you questions, Doctor, do you recall if you were using qualifiers to the same extent to his questions that you're using to mine?
Yes, I was.
You believe that you were using, in other words, in the answers you were given, that you were...
Absolutely.
Okay.
I would be saying it's post-event information suggestion can contaminate memory, not that it always does.
Would you agree that either strongly positive or strongly negative memories are stronger and more memorable than more neutral memories?
Yes.
And you've also said that the more significant an issue is, those are the ones that tend to stay with us. Is that correct?
Yes.
I want you to assume the following. I want you to assume that a close friend or family member tells another individual that they have helped cover up a homicide. Would you consider that, Doctor, to be a memorable event?
Well, I think it would be. I think it would be rather memorable in most situations.
Can you give me a situation, you said in most, please give me a situation where it would not be memorable.
It might not be memorable if the individual who heard the remark thought that the person was an exaggerator or a liar, for example.
Well, wait a minute, Doctor, would that mean that the person wouldn't remember it, or would that mean that the person wouldn't believe it?
They might not believe it, and they might not pay as much attention to it.
And Doctor, let me ask you something. What if you had 7 or 8 different people repeating what are in essence the same or similar memory? Would that give it more validity?
It could, unless they were exposed to similar sources of post-event suggestion or contaminating misinformation. Then you can get 7 or 8 people to all be believing, honestly believing in the same wrong thing.
Right, but that's going to be more of a situation where those 7 or 8 people know each other, have communication, or are subject to the same outside influences. Would you agree?
Yes.
It doesn't work as well when you have, let's say, people who don't know each other or people who are not exposed to the same outside influences. Would you agree?
Right. They can be, if they're not exposed to different suggestive influences.
What is the False Memory Syndrome Foundation?
The False Memory Syndrome Foundation is a foundation that was organized in, I believe, 1992 by some accused family members and concerned professionals who were kind of caught up in these delayed memory, repressed memory accusations.
Doctor, would you agree the way you just described it was, could you describe it this way as well? Would this be an accurate recitation? It was a group that was started by a person who was accused of having molested his daughter. Would that also be the same thing? You said caught up, etc. Would you agree that your answer kind of editorialized how the group came into?
No, I agree that my description is much more accurate than yours.
Did I ask you that question, or is that, again, something you just want to insert? Was that a question I just asked? What's the objection?
There was a question, there was an answer.
Doctor, is that, the answer you just gave, was that to a question I just asked you?
I thought you had been asking me a question.
It was.
So, Doctor, the false memory syndrome, would you agree, is a theory, it's a tool used to discredit those who allege as adults that they were victims of childhood sexual abuse. Is that correct?
I would disagree with that.
Would you agree, Doctor, that within your area of expertise, that there are many respected individuals with the same degrees you have that have described false memory theory or false memory syndrome as exactly what I just said, as a tool to discredit those who allege as adults that they were victims of childhood sexual abuse.
There's some people who would say that, yes.
And this is a syndrome that you've testified in support of as a paid expert witness, is that right?
I don't, I have talked about false memories of accusations of claims of repressed memory.
You would agree that false memory syndrome has never been ratified by the American Psychological Association or any other mainstream psychological diagnosis system as an actual diagnosis, is that correct?
It's not a diagnosis, it's the name of an organization.
No, false memory theory or false memory syndrome, that's not the name of an
False
organism.
memories,
False memory theory or false memory syndrome. That is what we just described, correct? That is a theory that individuals are, in essence, making up, imagining prior sexual molestation as children and reporting it as adults, correct? That's what that theory is about.
well, that's a position that kind of thing happens, and it does happen.
Doctor, and in fact, false memory theory and false memory syndrome, that's an area that you have testified about, is that correct?
I have testified about false memories.
Okay, and false memories with respect to adults who have come back and said, you know what, I was molested by my father as a child, correct?
Well, typically in cases where they're claiming they repressed their memories, yes.
Okay, and doctor, the False Memory Syndrome Foundation, that's the group that was created by Dr. Peter Freyd, F-R-E-Y-D, correct?
And the Peter and Pamela Fried
Oh, I
were
mispronounced it.
two of the accused adults who, along with others and concerned professionals, formed the False Memory Syndrome Foundation in 1992.
And so let me be clear. Is it Dr. Freyd? Am I pronouncing it right
It's
now?
fried like fried egg.
Okay, Dr. Fried, and that's F-R-E-Y-D, if I didn't say so. He was accused by his own daughter of child sexual abuse, is that correct?
Yes.
And doctor, you are a member of the False Memory Syndromes Foundation Scientific Advisory Board and have been so since 1992, is that correct?
No, the organization doesn't exist anymore, and I was one of 50 scientific and professional advisors to the organization.
In fact, that organization went away very quietly on December 31st of 2000 and either 19 or 20, is that correct?
The organization, grew out of existence.
So you have no association with that group at all?
No, it doesn't.
Can you tell me why it's still on your resume?
Because I was an advisory board member, and maybe I just didn't put the concluding date on there. I was an advisory board member of that organization.
Why don't you look at your resume, please, and why don't you indicate what
Well,
it says?
if you'll tell me what page it's on.
Boy, I'll try to find it. It's a long document. Let me see what I can do here. You can probably find it easier than I can.
Oh, it says that I was an advisory board member from 1992, and it doesn't have a concluding date, but it should. Because the organization stopped a few years ago, and so I should put a concluding date.
Right.
Thank you, I'll do that in the next revision.
I won't charge you for the resume
No,
work.
thank you.
So, doctor, you would agree that that organization was heavily criticized for the lack of scientific validation for what they were doing, correct?
I don't know that I would put it that way.
Well-
It was a fine, organization that tried to help the tens of thousands of falsely accused people and to communicate accurate science.
And when you say that Dr. Fried was falsely accused, that's your impression, correct?
Well, I don't know. I mean, I know something about those accusations, but
Well, you said falsely accused. You're not making a judgment as to whether he was falsely accused or not. Is that correct?
Right, the organization did not do findings of whether people were falsely accused or not, but I firmly believe that many individuals were.
Who was Dr. Ralph Underwager, Underwager?
He was I think a priest, psychologist or something who worked on various cases of, was concerned about child abuse. He passed away a few years ago.
He was a fellow member of that false memory syndrome foundation.
Well, there were 50 people are approximately on this advisory board.
If you'll allow me to finish my question, Doctor, before you start. I didn't finish. He was a fellow member, correct, of the False Memory Syndromes Foundation Scientific Advisory Board, correct?
I believe he was. I'd have to go back and look at the list, because...
You're aware it was a pretty public controversy. He was forced to resign from that board because of comments he made in support of the idea that choosing pedophilia
Objection,
was a
Your Honor.
responsible
Hearsay.
choice for individuals, correct?
Calls for hearsay.
What,
I think it's gets to be collateral.
It's also,
what,
I think it becomes collateral.
well,
You're
Your Honor, she's on
criticizing
this
us-
board.
Yeah, sustained.
Dr. Underswager, like you, he testified extensively on behalf of defendants in child sex abuse cases, correct?
objection, Your Honor.
Sustained.
Right.
4:30. So we'll be back tomorrow. We made it. We'll be back tomorrow at 9 o'clock. Do not converse among yourselves or with anyone else on any subject with this case. Do not form or express any opinion on the case. We'll resume tomorrow, Doctor, ordering you to return to this court. Do not discuss your testimony with any other witness.